and he forgot that he told me last week that it's all fine, but then he remembered now it's his mother's yard site, so he's going to give me as much time as he's able to because he says it's busy. But obviously we have opportunity here. Kneinharder, we have already a lot of our Talmidim coming. Amongst our classes that we teach, we learn together. One of the things we learn is Hilchas Nachlas, the laws of inheritance. And I always like to try to summarize the halachas that it shouldn't just be in the clouds, it should be down to earth, that everything we know, everything we study, everybody please mute your mic so you shouldn't hear any echo. And everything we study, we should have a grasp on. Talmud b'yodeh. Talmud, it doesn't only say Talmud b'moichi, that what you study you should have in your brain. You should have a grasp. It should be tangible. You know how to deal with it. And we hope and pray that we won't have to deal with this matter that we'll be talking about. But it's Torah, so it might as well know it well. There's a very fascinating things in halachas al pi Torah, in the concept of Jerusha, of inheritance. And one of the things I tried to do is I was told the most complicated cases to come to Beis Din and specifically have to be brought to Beis Din are cases of Jerusha. And the reason for that is inheritance, because in Jerusha there are some primary halachas that the secular court does different. And for that, if you and I actually saw the Aruch HaShulchan saying, if people are settling in court about inheritance issue and you don't follow the Torah view, it might be considered gzela, because you might be taking something that doesn't belong to you. So I asked two people who are experts in this field to come on. I would appreciate the more people put on their videos, to be better, so it doesn't look like we're just talking to a black screen. I asked Jonathan Dyrud, who's a close friend to the Jewish community here. Jonathan Dyrud's parnasa, I'm not saying he's not soliciting jobs, but his expertise is, he'll tell you how long he's doing, he's a will and trust lawyer. So I asked him to tell us, why is it important to make a will? It still shocks me that the story that I heard lately, that the Rebbe, the day the Rebbetzin passed away, the Rebbe called in Rabbi Krinsky and said, until today I never made a will. And now that the Rebbetzin passed away, he asked Rabbi Krinsky to find a lawyer to take care of the will. And a lot of nice halachas I've learned from the interviews of the lawyers with the will. So Rabbi Krinsky, Jonathan will tell us some of the secular parts of the importance of a will, what could go right, what could go wrong. And then Emir Tzashem, Rabbi Schochet's going to be on, and Rabbi Schochet just told me it's his mother's yahrzeit, so he can't give me all the time in the world, but he'll present the Torah view, what we have to be careful, when we're making a will. I just want to shoot a couple of obvious differences. Lapidus, your mic is on. Please mute your mic. I want to just obviously give you a couple of obvious differences. First of all, Al Pi Torah, whoever's mic is on, please mute it. Al Pi Torah, a b'chor gets double. Okay, just remember that. Al Pi Torah, this sounds harsh. Boys get Jerusha, girls, daughters do not get Jerusha. Now that's a little hard to swallow. So there obviously every father wants to leave something for all his children. So the halacha is around Jerusha. If it's structured as an inheritance, then these rules have to take place. If it's structured as a present, it's a whole different ballgame. Then you could give whoever you want. And that I'm going to ask Rabbi Schochet when he's on to clarify. Number one. Number two is a very fascinating thing. You go to the store, you want to buy a car, you want to buy anything, the sale ain't final until you make a kinyan. You have to make an act of a kinyan for the sale to be final. Either sign it, shake hands, whatever kinyan you make. The only transaction that we find that it happens without any form of a kinyan, it happens automatic, is Jerusha, inheritance. If you're only on the line of being on the top one, however it works with it, as an inheritor, as soon or immediate as the person passes away, it's yours automatic. You don't have to make something. You don't have to acquire it. It happens automatic, and that will also lead to some of the complications between lahavdil, the secular court, and the Jewish court. Okay, so you're not here to hear me speak. You hear me, Baruch Hashem, speak a lot. I'm going to ask Jonathan Dyrud again. He's a local lawyer. He's a great person. You look at him. He is the Gentile that the whole Minnesota's chametz is sold to. So don't get thrown off about his beard and his yarmulke, but he's going to come at it from the secular part. And then when Rabbi Schochet comes on, we'll try to squeeze him as much as he could for the time he's on. So Jonathan, you might have to raise your voice loud. Everybody, please shake your head if you hear him. Start something else. Say hi.
Hello.
Yeah? Okay,
Hello, I see a lot of heads speak.
Okay, speak up.
Moving. Okay, good. As the rabbi was just introducing some points about sharing between sons and daughters, something crossed to my mind. As soon as I'm done with finished a whole estate plan for someone, I encourage them, keep in mind that besides all the documents that we have taken care of, you can always open up another account with a broker, a bank, and handle something on the side. So say that halacha, you can take care of halacha by a will, and then handle, as much as you can, halacha by the will, and on the side, with the help of another rabbi, how should I share something for the women in the family? Just outside, because often a person might want to give something special to a grandson or a granddaughter or a friend who has done a great favor to you. You can always open up an account upon your death that goes to such a person. Just a thought.
Shmuel, could you please mute your mic? The only mic that should be on is Jonathan's mic. Shmuel. All right.
Okay. I believe that in every jurisdiction that you're in, they will have their own laws about inheritance. It's not a general law in the United States, or I think in any place. Minnesota has its own inheritance laws. The objective is to make inheritance according to the general feeling of the community. So we pass laws and we change them depending on what the changes are within the what would be favorable to the majority of the people in your jurisdiction. So they change from year to year often. And one thing that's a little bit disturbing, just so you know, that if you don't have your own will, the state has a will written for you already. So if you pass away, and in Minnesota, if your assets are above 75,000 and you don't have a successor named on those assets, then it goes through a probate court. And then you're subject, if you don't have a will, then you're subject to what the statutes are. And you have missed a lot of opportunities if you don't have your own document. I have a list of things that your own document can help you by in Minnesota. I've made a list. One thing in the Minnesota law about inheritance, they go by DNA instead of by who your legal children are. And so I think everyone in Minnesota, all the males especially, they should have their own will so they don't go by the DNA. If they find somebody who you thought had been adopted out to someone else, but something was messed up in the adoption, so they become your heir by surprise. So in all the wills I do, especially for men, I name the children, and I say if I left somebody out, I intentionally left them out. It was my intention. So it's clear that those DNA children don't come back in.
Interesting. In Shulchan Aruch, there's a whole Binyamin. Are you on Binyamin Diamond? There's a whole section of Shulchan Aruch where we're discussing. I'm sure it happens that pretty often that a wealthy man passes away, and a guy pops up from Hudson Plot says, I'm a relative.
That's why you need a will.
Okay, explain.
If you don't have a will, that Plot's kid will inherit along with the rest of the known children.
And what would he have to prove? How would he have to prove it?
You just have to show by DNA that he's your child, and that's not so hard to show. And so you have your own will, and you name your children, and you say, everyone else I have intentionally left out. It's not by mistake, and then you're safe from those children. I have many stories. That interesting story. A man, when I did a will for him, he said, I don't have any children. We found out that he did have children. It was in a trust, actually. We got a notice from a lawyer in California. This is the child. We can prove it's his child. However, it had a good ending. His wife had a child when he had spent 22 months in Japan, and there was no way he had access to his wife. And so in the divorce, the judge found specifically that such and such child is not his. That's an interesting turn of events. I was quite worried for a while until somebody came up with that divorce decree in which the judge took care of the issue. Is he ready? Okay. Something else that you should be aware of. Sometimes you might think you have taken care of all of outside of the will, taken care of to avoid probate by having everyone listed on every asset you have as a beneficiary. Your IRA, your 401k, your bank accounts, your broker accounts, your house, everything, you have it all listed up about who will be the successor. And then before you pass away, you win the lottery. And so it goes all kaput because you didn't have a will. You thought, oh, I'm taking care of it. I don't need a will because I have everyone listed as a beneficiary. And then an uncle dies, a cousin dies who left you $1 million. Suddenly it blows your, and then before you had a chance to make the corrections and adjust everything, you pass away. And so it all goes awry. So you should have your own will, even if you think you've done a great job in listing all your beneficiaries. I'm going to list some items. One of the reasons you want a will is naming who the executor is going to be, who the personal representative in Minnesota, we call it, because we want a person who's capable. We generally want somebody who's diplomatic, honest, will be trusted by the children and the beneficiaries. So he will do a good job and a good job in dealing with the estate.
I want to tell you an interesting halacha that's connected to that. Sometimes halacha says that when a father mentions a specific son in the will, it doesn't mean that he should get more than another. It means that the father felt was more capable of managing the estate. He made him more as a manager, not as, you have to read into it and what the father meant when he wrote that kid's name out.
But he should have been more careful to define exactly how the assets will be divided. One of the special reasons for having a will sometimes is if there's real estate, the question gets to be, say that there's real estate that you own, you pass away, the question is, should it be sold or should it be given, should the share be given out to certain individuals? And often, this is a little piece of information about the laws of Minnesota, at least you have to check with your own statutes. Minnesota's, if there's said that you have done a deed to avoid probate, you did a deed within the family, and you put 3 children on as beneficiaries, say that there's a life estate. You made, you had a life estate and you gave the remainder interest to the 3 children. That avoids probate, of course. Upon your death, the title goes to the 3 children. However, if they want, are all 3 going to live in the same house with their children and their wife? Probably not. So you like to have have the property go through probate rather than through the a deed to the three children, so it can be sold in the probate and the money divided. Another element, if the three children want to sell the property, their spouses in Minnesota, they have to join also. And sometimes you might have, on the day of the closing of the sale, you might have offended your spouse in some way. She said, if you want me to come to the closing and sign, I'm not going to come to the closing and sign. If you want me to do something else, I'm going to do something else, and not what you want me to do today. And then you can't sell the house until the wife will join. So often it's better to go through probate rather than do it by deeds within the family.
People are waiting, yeah. I sent you another link. There's no picture, nothing. I just sent you another link to get on. You can
in Minnesota, one of the nice features, a pleasant feature that we have in our statutes for probate, for wills, and that is you can give yourself permission to make notes outside of the will regarding tangible personal property. You want these books or this jewelry or these various items to go to specific children or grandchildren, and you give yourself permission in the will to make notes to that effect. And the will, if you have given yourself permission in your will to do this, then you'll be able to go through all of your personal tangible property and list who's going to inherit, or who's going to. You might have it go back to friends that you might have borrowed it from. Somebody had made you a gift of something, and you can list who's going to be getting everything by detail, and that'll be the priority. Generally, we say my spouse has the first choice. Even before you get to this list, giving yourself the permission on these lists, you say all of my tangible personal property will go to my spouse first, because usually you have collected these things over the years, and there gets to be an issue about who owns it. So you say my spouse gets everything first, and whatever my spouse doesn't choose will be according to the notes that I left. It's very helpful and useful. Yeah.
Is the list incorporated into the text of the will, or is it referenced and then there's a separate document of the list?
It's referenced, and you can have 100 of them, and you can change it from day to day. The later date will control. It's very helpful, very handy. Then we often will say everything else that doesn't go by the list will go in equal shares by value to my remaining children, as they may decide amongst themselves within a certain amount of time. And if they don't agree, then the personal representative will make the distribution among the rest of the children. And then if nobody wants it and it has value, if it's worth selling, then the personal representative will sell. And things that aren't worth selling, this is in the will, we put this language in the will, then it'll be given to charities or disposed of without any accounting. So if there's a stack of newspapers, they can't be blamed. Well, what did you do with that stack of newspapers? Well, it wasn't worth selling, and it's still in my garage. There's no accounting for that stack of newspapers. I cover all that in the will. So I encourage you to have a person with experience doing your will. Don't try to do your will yourself. There's a lot of issues that can be brought up that you have no idea about the importance of it, and the attorney will give you guidance regarding your general estate plan, so you don't miss something. In your will, you can say, well, I trust this person, so there doesn't have to be a bond. He doesn't need to be bonded. You can waive the bond already if you make that statement in the will. He's trusted. And you can say, I want it to be an informal probate, so you don't have to be going to the court and standing in front of a judge to have the probate process commence. So you can specify, have it go as informal or formal as the personal representative might desire. Something that, there's a lot of things that come up that I wish I could think of to share with you. But some people think that by having a will, they're avoiding probate. They think, well, they'll call me up and say, how much is it for a will? I want to have a will so I don't have a probate. Exactly backwards. You know, they don't understand that a will is a probate document that has no effect unless it's entered into the probate court process. So they'll say, I want a will so I don't have a probate. Then they have a lot to learn. You can sit down and give them a little seminar in your office about wills and estate planning. There's another point in general before Rabbi Schochet comes on that I want to make sure that that I bring up a couple of misapprehensions. Another misapprehension is I can't make a gift of more than $15,000 in any calendar year, because the law says, the IRS says I can't give away more than $15,000 to any given individual in any calendar year. That is exactly wrong. You can give away any amount that you want to. There's no limit whatsoever. The only issue is reporting it. There's a little IRS 709 form. You give away that, and you report the next year by April 15 what you gave away the prior year. And in some instances, it's valuable. Say if you have a child who's a barber or a waitress or this or that, and they deal in cash, and you can do them a great service by helping them file a 709 form so that the deposit in your bank account is not income. It was a gift from so-and-so. So then if there's ever an issue about where your money came from, then the answer will be with a 709 form. So I say, even if you give only $5,000 to this grandchild, or I mean to this relative, be sure you do the 709 form so it won't be mixed up with their taxable estate. There's another piece of information that I want everyone to understand is to avoid probate, you don't give away assets before you die. If you die, they can be stuck with a big tax bill when they try to sell it. So you want to be sure that if you're giving real estate, especially anything substantial, that it go to them upon your passing, because there's an unbelievable gift. I don't know who came up with this idea long ago, but throughout the United States, if somebody inherits from you because you die, somebody becomes the owner of something because you have passed away, all of the tax on the appreciation is forgiven. It's an amazing gift. So there's little illustrations that you can give and say, you find a diamond worth $1 million in the sand along a seashore. Be sure that it goes to your heir by the will. If you give it to them and they sell it, there'll be $1 million income tax on it because it cost you nothing. So the tax basis is zero. If you sell it, you'll have $1 million tax added to your income taxable. Capital gains tax, or in Minnesota, it's just been added onto your income tax. But if it goes to someone because you pass away, they can turn around and sell it, zero tax. Upon death, all capital gain tax is forgiven, but it's received to you upon death. It's a crucial piece of information. And there's, with real estate and that's owned between spouses, they've lived in it, they've owned for 5 years, they've lived in it for 2. There's in Minnesota, with the nature of my clients, they seldom have any capital gains tax when they sell it. So they can, because it's the gain, if the gain is a couple owned it, if the gain is less than 500,000, there's no capital gain tax on it. Or if it's a single individual living in the home for 2 years, having owned it for 5, the exemption from a capital gains tax is 250,000. very few of my clients ever have to worry about that. They can sell the property anytime and they don't have to worry about the tax. But if they, this is kind of gets to be very careful planning with the children about, say that you have a daughter who wants to come in and live in the home for 5 years, then you dare to actually give her the property outright, and they will take your tax basis in the property. But it's very seldom will you have a gain of $250,000 if they plan to live there for 5 years. Those are a couple of key elements that you should be aware of. And we have Rabbi Schochet coming.
Don't worry.
Okay.
You finished? Do you have any more?
Oh, there's always more. Gifts to charities is always something that you might want to cover in a will, or take care of that in a will or outside of the will somehow. That's a useful place to handle that in a will. If you have minor children, you'll probably most often want to have a will that's also a trust. It has a trust in the will. Or if you have a child that's somewhat incapacitated and needs some guidance regarding his assets, even to age 40 or 50, you can put a trust in the will, or you can set up a separate trust for that individual. And sometimes I had one client a few years ago. They had the lady was pregnant with 2 boys, and her whole life was all surrounding these little children that would be born. You should have seen that will. It was a trust will, of course. It had a trust, but she named a list of 10 consecutive individuals to be guardians of the children. If something happened to her, then she would have a list by priority of who would be the guardians of the children, who would be the trustee of the trust. And she even made a committee. If none of those individuals were willing, then she had a committee named who would be choosing who the guardian would be or who the trustee would be. It was quite an interesting experience working with this couple that had their only focus in life with these twin boys who were to be born soon. That was quite an interesting experience. But yes.
Okay, so Rabbi Shochet is helping getting Rabbi Schochet on. So I'm going to cover a couple of halachas that I'm going to cover a couple of halachas that you might not know from Hilchos Nachlas. And then Rabbi first of all, Shikar, thank you very, very much, Jonathan. I hope that was important information. And I'm sure Al Pi Torah, there might be a little things that we have to do a little different. So first things first, I want to share with you a halacha. You think it's just optional? The halacha says like this in Siman Reish Pei Beis: Kol hanoisei nechasav la'acherim. Anybody who decides to give away his money, his assets to others, v'hiniach Yerushim, and he leaves over ones who should be inheriting him, and whatever reason. And the Shulchan Aruch is very specific. Even if they don't behave well, they never got along. If you take away money from your inheritors and give it to somebody else, that even though the Yerushim are not behaving properly, the Chachamim are not happy with a parent who does something like that, because it's sort of, they have the rights to the money. Believe it or not, Shulchan Aruch says as a Jerusha, you're not allowed to take. It's their. It doesn't make sense to use the words hard-earned money. It's not their hard-earned money, but that is their money. You know, the Chinuch says a fascinating thing about the mitzvah of Nachal, the mitzvah of Jerusha. He says, and he proves it by saying that the sons or whoever inherits doesn't have to do anything to get the Jerusha. It's automatic. He says the Eibishter wants to show how everything in this world belongs to him. This is how he interprets the time, the reason for the mitzvah of Nachla. Everything in the world belongs to Hashem, and everything has an everlasting effect. You can't shift it around. Over even something like financial estate. Once the person's time in this world, then according to the Torah, it goes down to the next generation. And you can't maneuver around the master plan of the Eibishter. It's somewhere a lack of emunah. That's how the Chinuch puts it in the mitzvah of the Jerusha. Another thing which you find fascinating is, let me see if Rabbi Schochet made it on. Rabbi Schochet? No. Another thing I found fascinating, when you go through the Rambam, the Rambam, when he's the Moina mitzvahs, when he counts the mitzvahs, the last mitzvah of the Ramach mitzvah essay is the mitzvah of Lodun B'dinei Nachlas, to judge and settle cases of inheritance. The last one of the Ramach mitzvah essay. Now it's funny, the writing, it's actually connected to last week's Parsha, because it goes on the order: settle fights between people, settle disputes, settling deposits, and also the last halacha, the last one of the Ramach mitzvah essay, is to settle lodun b'dinei nachlis. It's a mitzvah min haTorah. Rabbi Schochet, you on? Somebody else just came on. So obviously, just like in many other cases, you're not allowed to make deals and conditions with what the Torah demands. So there's a lot in the Jerusha that also you should know that there's a mitzvah min haTorah. So after all you heard from Jonathan and all the legal protection you want to take, it seems to be that I hear it that there are some people that even though they want to give different things to different kids and maybe not do exactly as it's, so they set it up, as I said, as a matana, but they still use a certain amount of money, maybe very small amount of money, that they try to share it al pi Torah, which would be a bechor twice, double, and everybody else. Baruch Hashem, Rabbi Schochet. Rabbi Schochet, I hope everybody sees Rabbi Schochet. Rabbi Schochet, you gave him an opportunity for 25 minutes to give the legal view. But now we're going to hear the Torah view. And I do want to tell you, Rabbi Schochet, I got a request over here from somebody. He asked me like this. When I was asking the Rav, is there a standard? I would think that the Batei Din would want to preempt a lot of these issues by making a form that can be stand up in Jewish and in secular court.
Okay, let's start.
Everybody else, mute your mic, please. Whoever's the phone, 651-303, whatever, mute your mic. Thank you.
The first thing in a document is the date and the place where the document was written. That can be sometimes it can change the whole situation. There is, when Chas v'Shalom, somebody passes away in Eretz Yisrael. Over here is a different day, because over there it's 7 hours difference. So when it can be sometimes that a person can save himself their whole shiva. Let's say somebody passes away, it says Erev Yontef here. Here it's Erev Yontef, over this already Yontef. He gets the notification before Yontef, and he sits only till Yontef, because Yontef takes away the shiva. So it comes out the very fact that over there the sit shiva, he's not have to sit shiva at all, because here it was before Yontef, and he writes on. The same kind of happens. What is when you don't hear the Megillah? You don't have the Megillah. It's the Purim, you don't have the Megillah. You can take a jet and go to California from Toronto, for instance, in Toronto. There it's still Purim. It's 3 days, 3 hours difference. And I can hear the Megillah. A Yotze is still Megillah, I can catch up. Usually when it's over Zman Bottle Koben. Here you can, so it's important, especially the Gemara discusses when for instance a chas v'sholom an accident happens, and a husband and a son get killed. It's a very different who was killed first. If the son was killed first, the son is not a Yerush. Who Yarshins? The rest of the family. The son was already dead. It's not a Yerush, and in all the Inyonim. So therefore, it's important to know the date and the place, because it depends where you are. When you are in China, whatever, it's a different day. So this is one of the important issues. What is in a document very often you can mess up if it is the right day, and so on and so on. And that makes a difference.
Rabbi Schochet, but that's not even al Torah. That lahavdil is even secular, correct?
That could be affecting the secular too. The date is very important. Especially it is different because the Goyish date is a different date than the US. The Goyish date starts at 1 o'clock at midnight. Our date starts in the evening. So when it's the date that may not correspond, can be a whole din Torah and everything. And the people get very, they think so, and it's very solution. Look what if it's a Jewish date, when it's finished, when it starts a date, when it's a thing. And it is also important by they used to write sometimes in the star the hour. The hour. When it's the hour, then it's very clear, because it can be both is star matono, both of the same date. When they write the hour, then see now this one was first and this was later. So we don't write the hour, but it sometimes can be important when they write the hour to clarify the thing. Very often, the problems with Jerusha is they question what was said and they question the evidence or whatever. What happens? I happened just this week to two cases. Jerusha, the person had passed away, but they say they have evidence, a video where the father said, I want to have sholem, everybody shall get equal. Everybody shall get equal. First of all, the question is, the person feels he did the right thing, but sholem is a great thing. But the Torah doesn't say everybody takes equal. A bchoiro is different. A woman, a wife doesn't inherit. A daughter doesn't inherit. So a person wants his daughter to have Jerusha. So he said, he figures he's already yoytze. He calls all the children, all the eneklech, everything shall have equal. We take a recording. Everything equal, that's Masa Masha Kosher Batero. You have the right with your property to give it to whoever you want, as long as you're alive. You say, after my dad, everybody shall take equal. You have no right after your death, that the Torah already deserves. That's Masne Ashmashe Kosher Batero. It makes a condition that contradicts what the Torah says. It's void. So by a document, it's very important in what is exactly written, what is right. And actually, it's not only by a will. It can be enough gemine by Ksube too. By Ksube, when did the right Ksube? When is Chal the Ksube? When is Chal from the Ksube? Once they make a kinyan. So it can be everything is properly, whatever, there was no made a kinyan. What is a kinyan? A kinyan is what I said before, when your life, you're the boss of your property. You can give it over to whoever you want. You can give it a charity. You can give it to Hefker. That is your right, as long as you're alive. So when it is a matter there, Many people make mistakes. They say they feel it's a singer. I made a video, whatever. They feel like. So by document, it's very important to have the clearness what you want. And the best thing is to have a roof with you that gives you information how to make it proper in order it shall be validity. Otherwise, it may not lose the validity.
Rabbi Schochet, sorry, could I interrupt? I asked you a question. We keep on hearing this about that the wife doesn't get a Jerusha, the daughter doesn't get Jerusha. So, but yet people want to give every. Is it wrong halachically, or is it not wrong to take? Is it wrong to give it to them as matana, or it's not wrong?
A matana you can give. That's sure the same as you can.
But is that a wrong thing to do, or it's not? If the Torah wants it different.
It is not wrong when it is to a Jewish. When it's not to a Jewish, it's wrong completely. And so the thing is, in your lifetime, you can do whatever you want. In your lifetime, there is, even though there's certain restriction that you can have something wrong. For instance, your wife gives a big donation. It comes a person, he cries. He said, Rebbetzin, you know that the people are dying or whatever, and you move her heart, or she says, and she gives a big donation. The big donation is illegal. Why is it illegal? Because the owner of the money is the husband. And the husband gives the right to the women to give a certain amount. Certain amount is up to $100, $200, whatever. She gave it $10,000. He said, "What's about? Are you crazy?" Then the thing is bottled. She has not the right to give it. She has a right to give the amount, what I think. So she says, "You always give me permission to give the charity." By Rivko, she told Yaakov, "I have a right to give every day to spend so and so much. If I can give, when she's not right, then she cannot give."
647-300-3206. No.
How about it? Jonathan wants to know, how about a death, a present that a person gets after the death?
If they have a pay on death, like transfer on death account.
After that, you cannot transfer. However, the idea you can do, we can take only schayvus. Balchoif, a person that you owe money, comes before the Yerush. So when there is a debt that you have, the person that you own it comes before the Yerush. Because that's so what you can do, we want to, your daughter inherit. You can do it in 2 ways, 3 ways. When you want, you can give them the present in their lifetime. You have stocks or whatever, you can give it to them. You cannot write in the will, you take 10%. Because the 10% is money maybe that you earned after the time that you gave it away. After we gave it away, that's no kinyan there. But you can say, can take its chayvus. That's the way you make it a will. You take on, I take on myself that my daughter shall inherit. I owe my daughter $1 million. And you're right. Sons, if you give my daughter a dirt or the same as you take, an evil chair, then it's bottled, it's matona. With condition. So therefore, they gladly give her the portion, the same thing. Otherwise, she takes $1 million, more than she would get. You make a kischayvus. I take upon myself a debt to my daughter, this and this amount. That's valid.
And the schayvus is a larger sum than the Jerusha.
Equal amount. That is the plain thing to make. Some user also, they write a will, a regular will, a goyische will, but they have an other star. They say the will that they wrote is because dine de machusa. The true will is this what they say now. By the halachical will. So it can be a chayvus or a matono. A matono will work. For instance, is a landowner, he has many houses. He said, I want the house to go to my daughter. That's fine. That's good. It's valid. Can be to anybody. Can be a poshut. I had just a case this week. A son was a nutzlach. The parents, they think when the person died, then the mother said in the lifetime, I don't want you to throw him out of the house. Leave in the house. So the non-children, I mean, the in-laws or whatever, they said that means he cannot throw him out of the house. The house, we can live there in the house. But when it comes after 120, we want the child in the house. It's not belong to him. He's not the only, he has a right to live there. So therefore is always important, the more they specify it, becomes clearer. Otherwise, we will always dispute, and it's the worst dispute that you have after Jerusha. Because the Atmas Nefesh for the Niftorim, children fight, and this is very bitter fights. Sometimes for a Narishkeit, sometimes for a Narishkeit, for a jewelry or whatever. Mother told me she loves me or whatever. It gives great pain to the Yorshim. It is a fight and so on. And therefore it's very important when you're very precise, and it shall be al pi halacha, al pi Torah. A b'choyer, in order to be yotzei b'choyer, you can give the b'choyer more in a certain thing. He takes the sforim, he takes the tefillin, he takes the other what. There is dollars that you have from the Rebbe still, whatever. You give him a special thing.
That's not the black and white what Shulchan Aruch says. Shulchan Aruch says that he gets mamish double.
It takes double, but it says clearly in Shulchan Aruch, when you don't give him extra double, it's also valid. It's valid. It's not a master shamash Kosher Batayro. You can make the thing because you have a right, especially when you make it. I don't hear you.
Now, 1 second. Somebody else is on mic. And we tell that person to lower the mic. 1 second. 1 second. Okay. I think they're off. Yeah, they're off.
You mean disputes is in many ways. There can be, you have a daughter-in-law, when she got married, you gave her a present. And then Chas v'Sholom, when your son passes away, then you say, under this condition, I didn't want her to have it. I wanted it's a married life, whatever. Or it can be other situation, a divorce, Chas v'Sholom. A divorce, you say, under this condition, I didn't give my wife the present. I will give the present in order she live together. And we speak when there is no transgression from the women. When it's a transgression, she was not faithful or whatever, then all this is bottle, whatever. So there is in a document, you can bewarn all these issues. But first of all, it has to be a legal document. Legal document shall be signed by two witnesses. By two witnesses. I have not two witnesses right now. Is at least Sav Yodoi. That means they can identify your handwriting. Is Sav Yodoi, whatever is a validity. And then again, it has to be, as I mentioned before, when you write the date, it has to be also the place, because as it can be in another place, it can be a different day, and so on. And all this in order to make the document legal. And then you have to know also the witness have to be kosher witness.
Yeah.
What is kosher witness? It's important for you to know. Always when I have a chasene, and you have to have witness the tnoim and the ksube. I told all the witness has to be to tshuve. When they don't tshuve, you are transgressing many transgressions. That can make this qualify as a witness by the by the brisker, when a person is chodosh, they disqualify to be a kosher witness. You know what chodosh is? You eat from what grew after Pesach. You're not allowed to eat till the next Pesach. So they say when a person is chodosh, there is one opinion that holds chodosh is not by Hutzlovitz or whatever, or from the Jewish field or whatever. But Al Capone, they disqualify a person in chodosh. Some disqualify from a person that shaves himself. I speak now, he shaves him kosher, not with a razor. With a razor, everybody is qualified. But when he shaves himself with a kosher razor, with the electrical thing, with scissors or whatever, he's qualified. So therefore, it has to be kosher witness.
Rabbi Schochet, sorry. Rabbi Schochet, I think, Baruch Hashem, we have about 25, 30 people here. And in this group, we have lawyers, we have accountants. I think if you could give them a couple of minutes, whoever has a couple of questions, and you have the opportunity to ask Rabbi Schochet, let's do it that way. We'll start. I will direct the traffic. Okay. Usher, anything to ask Rabbi Schochet? Put on your mic. Usher is an accountant in New York.
Okay. I don't see him.
Unmute. Yeah, hi. Question. A lot of my clients putting their money into trusts, and they're not the trustees. Would a trust be considered a gift in lifetime or not? How would a trust be considered in a halacha?
Good question. Because it's negay also for a pchoyer. A pchoyer that takes double, and the father just space it with the pchoyer double. Double, he only takes what is available in the estate. Something that is to be collected, a debt that is collected to the state, he doesn't take double from that. You only take what's already collected. So therefore, double is only what was already collected, was cash. Trust can be different. I don't know in what way the trust was set up. If it is always cashable right away, it's already like here. If it's not cashable, what's in the bank is cashable. When it is a matter that is collected, a debt, milvolat so nitno. For instance, you cannot marry a woman with a debt. He owns me $1,000. You shall be married to me with the $1,000 the guy owns me. He will have to pay you. It's not milvolat so. It's not considered like the cashable right down here. So therefore, a trust can be different way. If it's already there, then it's a different thing. So some hold even that a banknote is not considered cash. It's not considered cash. Why? Because in the old banknotes, you know what it says in the old banknotes. This banknote is cashable for gold. The bank has to give you gold on that. It's a debt. It's not a value. By us, we consider the value. So it's not. What is money? What is paper money? Paper money is something that goes up and down in value, whatever. When it was it was covered with gold, the olden time. It's a Schochet. Schochet, you cannot be married.
Okay. The other question I have is a very pertinent question. Is
the incident that is again also by Machzer shekel. Some say Machzer shekel shall be silver. It shall not be a banknote. It shall be actually cash.
Okay. Besides money, one of the biggest issues we have when we set up wills is guardians for the children. If God forbid the parents pass away and they're young children, according to the halacha, who is responsible for the children? If they didn't set up, normally we advise, of course, to set up guardians and appoint somebody. But if they didn't do that, according to halacha, who is first responsible to take care of their children?
Actually, the children's responsibility is the bezdin. The bezdin, when they are orphans, who takes care of the money that they inherit. The Bezdin put appoints an apotropos, a guardian. We take care. Today is more complicated because of the legal implication or whatever, but the responsibility would be on the Bezdin.
But does that really happen? Take it. He's in Crown Heights. If there's does that really happen? The Bezdin kicks in automatically.
Usually the people put a provision, something in the thing. Therefore, you have the legality. The will, whatever they get from the government. What do you want with your body to be done? The organs or whatever. And it also gives there who shall be your apotropos. When you are in Chas v'Shalom now in the sickness, what shall be your treatment? Especially now, the government says that I see legalized assisted suicide. And there's big pressure usually on the doctors. They say your father is gone. He's only a vegetable. So therefore, why do you do it? But he can still suffer. So take him out the suffering. We withdraw a cancer patient. They withdraw him, they dies from hunger. They withdraw all the sustenance. They don't give him any food anymore. There's certain thing that he can go in the wrong pipe or whatever. But when you have a person like that, I would advise to have a feeding tube in the stomach that goes direct in the stomach. A feeding tube takes away of many things already. What takes away when they is in a non-kosher nursing home, they give no kosher food. You're responsible for loisachilom. You shall not give a non-kosher food. When it's a feeding tube, there's no treifus, because eating means it goes through a normal way. When it goes a feeding tube, it's not treifus. It's from a certain way, it's an easy way for the children to put a feeding tube in the stomach. But there is this living will in many aspects of the organs. You don't have an accident or whatever, and so on and so on and so on. But how they shall treat you, in what kind of when you cannot control yourself, when you lost your brain or whatever, and so on and so on.
Okay, so, before we move on to the next, Usher, I'm very good in reading facial, and I see from your face that you don't think you got your answers.
I'm not sure. Well, there are different answers. I'm not sure on that. I guess that's why it's very, very important, crucial, that they appoint guardians for children. And that's usually, we stress that as a very, very important point in a will for children. Of course, also we, social needs trust and different aspects of it. But when we work with clients, especially young couples and with young children, we find that that's the one thing that holds up making a will. Who will be the guardians? And many young parents hate to face the fact that something could happen to them. But that's very, very important. And how you deal with it and the money and so on.
In that context, I want to tell you something. There was a guy in Poland years ago, and he looked for make a living in America. He left the family in Poland, and it figured when he goes to America, he will make money. And he will send his wife. But they had no bank account, whatever. How can you send money? He told a friend that had a bank account. You told them, I send you the money, give to my wife. How much shall I give your wife? Whatever you want. Whatever you want to give my wife. And the rest you can keep. Time passed by. The wife, they got a letter, Baruch Hashem, you see. But the guy gave her pennies. So one day she wrote to her husband, he can get pennies. So they told her, go to the Hof to go to the interior. Came to the interior and he said that the guy said, what do you mean? Yes, I keep 50%, I keep 80%. The guy told me I can give her what I want. So I said, say it again. The guy told me to give her what I want. You took 80%, that's what you want. Give her that. Give her 80%, you say you give her what you want. What you want, you shall give her. You want to give 80%, you have to give her 80%. So this is the person, that's what belongs to her. It is very important what is set up. It will be always necessary, a clearness. Usually by children, when a person knows he can happy, actually he leaves it to a relative, uncle, mother-in-law, or whatever. That is the normal way. Or a good friend that he trusts. But the elder is important. When you write it down, it's always important. Because when you give it to Apetupes, who is it? He figures yeshiva education, that's an extra thing, that's not necessary. It's not necessary to life. Want to have a special education, it's very expensive. If you specify, I want my children to have this and this kind of education. For this should we spend the money. The Yorkshire themselves, they can figure, he say, now 90 years old, I want a car, I want this, I want that. So it is important, and that is very hard. Who sees the future, who knows who the children will go up, who knows all these things. It's very difficult. Therefore, to appoint somebody that is that is knows all the details, knows what the Jew needs or whatever, is different than just going Shabbatupis.
Okay, Rabbi Shah, Rabbi say I'm going to allow first the chaver who I know are lawyers. I think this is their field, and then I know we have other professions that it might be connected to. Let's start. Yaakov Chaim. I don't know if that's your field. Yaakov Chaim is in Rhode Island, a lawyer in Rhode Island. Usher, mute your mic.
Okay. Good morning, and thank you very much. I do handle litigation matters, and oftentimes what happens is families come to us where there was a death with either usually the patriarch of the family, and the Yetzer Hara kicks in, and they have severe disagreements with regard to how they feel the money or the businesses should be shared. The real problems seem to arise when it's a matter of just dollars and cents. That's something that can be handled because it's relatively cut and dry. However, the issues come up when it's a family business and you have somebody who's involved in a family business, and the person who's most involved in the family business thinks that they should have a larger share, but that's not the way that the document reads. So what is the halacha when you're dealing with a situation where the patriarch of the family dies, there are family businesses, and there's a dispute amongst the children as to how that should be divided up and should go? That's the first question. The other question is oftentimes there's a dispute that the parent didn't, that's not what the parent said. And the parent wasn't of right mind at the time that they wrote the will. That
is very sad. Usually they say he had Alzheimer's, he doesn't know what he said.
Yeah.
Therefore it's not valid. Therefore it's not valid. That is it's very sad. They make the parents meshuge for the few dollars. They say the parents were meshuge.
Mm-hmm. Right. But I do run into all the time the issues where it's a family business and there are disputes with regard to how that's supposed to be handled. How does the Bet Din handle that?
First of all, the thing is like this. The dispute is what was the intention or is entitled. The owner of the money can say what is entitled. Even the guy did everything for the father, but they don't want to give money. There's no schayvus for me to give money. So therefore, regardless that he feels entitled, there is some situation. For instance, the father is old or whatever, and there is a daughter that takes care of him. Now a dispute is entirely different. I entitled to take the money that of the value that I spent on the parents. I spent a whole year, 2 years or whatever. So for this, I'm entitled to this amount. Let's say, and that's about formula. They find out how much would be a caretaker take money. That's the person entitled. It's nothing to dispute. It's nothing with the will, because the person spent on the parent this and this amount. It's entitled. But all the other items, the father was not by when he make the will or whatever. Is in halacha is a moitzi mechaver olavarei. Bring proof. Otherwise, we take the evidence that we see it. Proof means witness, kosher witness. When there's no kosher witness, we take by face value what we see here. Even there's certain circumstantial evidence. It's not evidence in halacha. But there is a moitzi mechaver. This is the they have written. This is what it says. This is the plain meaning of the words. This counts. Because he had the right to throw away the money.
I want to, if I understand Yaakov Chaim, let's say there's a father that had a successful business. He had one son in the business and another son a shliach and another son just started. So the one who's in the business feels like he has 2 feet ahead of everybody. He's invested, and how do you deal with that? That's as Yaakov Chaim. That's what you're talking about, right?
That is exactly what he said. But again, when it was not given him in the lifetime of the father, he's not entitled. He cannot take himself. Even you take in
But he's the only one that knows the business. The brother, the shliach.
So therefore, the person, whatever they explain, when he stays in business, you have a better share, a better chance to continue get money from it. When he goes out, the business goes kaput. So therefore, it's in the interest, perhaps, from the Yorshim to leave the guy in place, and they take whatever the monthly checks or whatever, and they're better off.
Yeah, the difficulty is that so the person who's the president of the company, the young man who takes over from the father, so he's running it, and so the way it should work is that he gets paid the proper salary, but he's also in control of how much profit is put out. So he can say, so they can play a game where they can control and say, oh, there wasn't profit this year, so that there wasn't any much to give out. At some point, does the Bet Din come in and say, no, we're going to have somebody who's going to look into the books of the company and see what is appropriate for what should be given on a yearly basis?
Yeah, you have to know, by Adin Torah, the parties are entitled to all the paperwork.
Call from Kaplan.
They are entitled to all the paperwork. And therefore, the person, when they say they want to check it out, they're right to check it out. Sometimes it's not worth it because it can cost very expensive.
Mm-hmm.
What is it called? The one that investigates the thing, the books.
Yeah, you can have an accountant who goes in and does who goes in, reviews the books and records and makes a determination. A forensic accountant.
That can be very expensive.
They are.
It can be very expensive. So therefore, they will in the last minute say, okay, let's settle whatever. But they're entitled. Very often common things they say that this is or make cheshbonis, the valuation, how much it's worth. Maybe it's more worth. Maybe this jewelry is worth more, whatever. but the entitled people were the entitled. The only thing is the one that asked for it, and what's later on shown it was not necessary, they can be hold that he shall pay for this. You shall hear, good, you're entitled, but when it comes out, you were not entitled, whatever, you pay for it. So that will give him a second thought. Shall he ask for it or not?
Okay, let's move on. Rabbi Schochet really stole away some time from his day. Elio is Rabbi Schochet. He's from Toronto. You know a place called Toronto? So Elio is there, and he's actually going to be a mouthpiece for a lawyer sitting next to him.
Okay.
Good afternoon, Rabbi Schochet. Thank you, Rabbi Wilhelm. Yes, my wife is a lawyer, and she's sitting right next to me, and she's asking questions. So the question we want to ask today is: so what happens when the halachic will is not exactly in accordance with a civil will? You need to write up a will according to the laws of the land, and that is the will that would need to stand up, chas v'shalom, if it went to court. What happens if the two have to be different?
There is another halacha. There is mitzvah chayim divrei hames. It's a mitzvah when we know he wanted it to fulfill his wish. So there's a special halacha when we know clearly he wanted it. He wanted this to go to this and this thing. He was not learned. He doesn't know how to make a will or whatever. But we know that what is wished, that's what he wanted. It's a mitzvah to fulfill it. Maybe not legal obligation, but it's a mitzvah. A mitzvah is also a legal obligation, a moral obligation. It's mitzvah lekayim divrei hames.
He's no lawyer.
So when a lawyer knows he was when the person died, and the person told him that this is what they want. So the lawyer can give it over to them and say, that was your father's wish. So why should you fulfill it?
And okay, and so if the halachic will is different, so you're saying that if it went to court, the court would uphold which will?
In court, they would not say, but they say he wanted it. What's the evidence? Did he say it in ink? We have a law that the divrei shivre merah, when a person is on deathbed, what he says is like it's written in a will. That's a law. It's not. That's only by shriv merah when he is on his deathbed. Then the words is like, in order that it shall not be, the Chachomim made the takon, in order it shall not be worried, they will hasten his death. But divrei shivre merah is like the written in, and the witness can say that what he said in his deathbed, and that is binding. But otherwise, words. He said once he was in a good mood or whatever, and he said, I mean, there's no evidence. In fact, in halacha is a very interesting halacha. When you say in front of the guys, yeah, I own you $1 million. He comes now, goes, takes to the din Torah. He said in front of witness, he can say, Meshate ani boch. I made a joke. What are you talking about? I owe you $1 million. I was making a joke in front of the people, but it's not binding. Wherever he can say Meshate ani boch, even says in front of the Besdin, he cannot say later on, I was making a joke. In front of the Besdin, a very serious matter.
And what happens if the civil will was signed by non-kosher witnesses?
Then you have no witness, but it's nothing. The person that claims, he says, you see, it's signed. The person with what we answer. He can answer. It's a goyim. It's not no. That's a good answer. But when he doesn't answer, otherwise, why do we ask? Why do the best knows not worth anything? Because sometimes he can be motivated, he can be embarrassed. The goy knows that I said it. They're going to go again. therefore gets embarrassed and they may admit the truth. The circumstantial thing can spur him to tell the truth because he doesn't want to be open a liar. Everybody knows a liar. He says the truth. And they say applies, he brings evidence that evidence, a movie is not evidence. Go Hollywood is all fake news. So therefore, it's only about the circumstantial evidence. Circumstantial evidence in Allah is no raya. But it would be, he can show it. If he asks the other one, what do you answer? Very often it can be, when it's true, he knows it's true, he gets embarrassed, he will admit.
Okay, anything else, Julio?
No, I'm good. Thank you.
Okay, now we have Toivel Shemayim Toivel Brias. We have Dr. Grossman. He's a doctor and his wife is a lawyer from Alo Zayton.
Good.
I just wanted to thank you for that. I just wanted to understand the point here. So it appears that one should write a civil will and have that properly done according to the rules of the state that you live in. And then, in addition to that, you have to have a halachic document. And it appears that that document is going to state that the people that would normally not inherit, the daughters, the wife, so you're going to say that you have a debt to them of an amount of money that exceeds the amount that they would get from the will, with a provision that if the executor of the estate doesn't want to pay the debt first, then he can follow the provisions of the will and distribute the assets accordingly, and that would cancel the debt. So we need to know where this document is and how do we properly execute this document. And I will also ask, because the question was asked before, if you want to appoint guardians to minor children, a civil will certainly have that provision. And what do we put in the halachic will to see to it that that is followed accordingly, so that this question doesn't go to the Besdin to pick a guardian? So those are the two questions. Where is this document? What does it look like? How do we fill it out? And what do we do regarding guardians and this document?
The last thing is the most important thing, because that is the future of the children. So in the will, you can specify you want them to have a religious education. But today that doesn't mean anything. Religious education is modern Orthodox, Hasidic, or whatever, Breslau. So therefore you have to specify, and what means that means you appoint a rabbinical authority to decide the point what is considered a religious education. The Shili Klat Kosher, the Paspalter, or whatever. You have to determine to what standard it is.
If that's going to go in the civil document?
Yes, it's going in the civil document. And incidentally, you have this also a problem. In the driver license or whatever, they ask what will be with your organs. Now you say, I don't want my organs, I shall be buried with all my organs. You cannot write, don't donate the organs. Because when you write, don't donate my organs, I don't want to donate my organs, then that will make bad for many Jews. The Goyim will say the Jews don't give their organs. Why should we give our organs to Jews? We don't give any organs to Jews. In fact, in Europe, they didn't want to take organs. They have all the countries in Israel. The Jews don't give organs. So what do you write? You say they give organs in according to this and this rabbi. Direction. Otherwise, there is even more. They may take your organs when it's still alive, because certain organs are thing. You write your death conviction. They kill you in order to the organs, and they say it was brain dead, but the heart was still pumping, whatever. There has to be a rabbinic authority, and you shall know they go and respect this thing. When there was the Siamese twin in England, they had to operate. They killed one of them because otherwise the boat will die. The doctor that they were going, he sent the Shaile to Rab Moshe Feinstein. Rab Moshe Feinstein was studying this for a few days. And then he came up with the answer. He asked many questions. They came in with an answer. So therefore, it is a matter. It's a rabbinical authority. You don't take a rabbinical authority for the thousand of things. The rabbinical authority is just a yukul. It's a kopmensch. He knows in this field. Otherwise, he doesn't know in this field. He may be a rabbi, but he doesn't know. So the authority. So you have to know who and
So
what.
he names which rabbi, he should name which rabbi he would want to be asked.
But that's going to go in the civil document. What goes in the halachic document? Just the debt? What's the text say?
In the halachic document, you can specify it. You can specify, give a matone. You have a thing. It shall be a matone, clear matone. Shall be from the state given so and so much. The only what you have to know, when in matone, there shall be also sometimes a kinyan. When there's no kinyan, it's no validity. It should be made a kinyan in front of the witness. If it can be symbolic kinyan. Doesn't have to give the money in his hand, but it can be a kinyan, a gavur suder. He lifted after a cattle or whatever, and it says and be witness the witnesses.
So finally, one more question, and that is, so we're going to have a civil will drawn up properly, and then we're going to have a halachic will done properly, and they should be kept together, correct?
Yes.
They're kept together so that when the time comes, then they are both produced so that everything is done the way we wanted it, and according to halacha. So the two documents should be kept together.
But the civil will shall not contradict the Hebrew will. When it contradicts, then have a big problem. Because the civil has also, it was from the person, and then it's a question who was first, etc., etc., etc.
Can I use it?
Okay, yeah.
Can I ask a question?
Yeah.
Today, in a package, when clients make a will, medical proxy, power of attorney, and so on, one of the items they have now is a living will. That is, in case, God forbid, somebody's very sick, how to treat it. Is that okay according to halacha?
Yeah, obviously, maybe it's necessary. Because when the person is sick, whatever, and has children, they may put him in a non-kosher nursing home. He cannot speak anymore. They give him a person who was a Shema Torah mitzvah their whole life. Now they feed him with chazer. So therefore, they specify what he wants to be the end of his days or whatever. It's very important. More than that, there's many Jews, unfortunately, that buried in Goyish cemeteries, in Hicktown or in South America, whatever. It's very expensive to transport or whatever. So the children, they don't want to spend money or whatever. They're buried in the Goyish cemetery. And that is something that Jews, when they came to other countries, they were the first thing they were looking for, a Kever Israel. They used to spend a quarter a week to skip the Chevy Kaddish or whatever, to be buried in a Jewish cemetery. Here we don't have the feeling anymore, whatever. That was really, so all this should be in living will, especially as I say, the living will, they put great pressure on the person, on the children. Your father's a vegetable, your father's already he doesn't know anything. It's a vegetable. By believing in suffering, we can ease him away. Don't make him suffer. Person loves his father, he doesn't suffer, he suffers. It's very prophesying, especially now that they may have legalized assisted suicide or whatever. Sometimes you can take it in a way. The government is interested not to have sick people. Sick person costs the OHIP or whatever, the medical insurance, lots of money. When you get rid of them, it's better for them, it's cheaper for them.
Okay, you got your question answered? Okay, you got your question? Your mic is off.
Well, I just thought that according to halacha, we have to do whatever we can to preserve a life, as long as it takes. And over here, we're telling actually the doctors, don't do anything. Stop taking it. Don't put in machines. Stop it. So that contradiction, sort of.
No. The thing is like this. We have a duty to extend life as much as you can. However, there can be a situation, for instance, a person has a cancer and he has very great pain every day. They told him, we can extend your life, we go on chemotherapy. The person says, it's never refuah. That means they extended my stuff for him. I don't want to take chemotherapy. And this is a right. He has a right to say he don't want this treatment. He doesn't have to. He doesn't have to take chemotherapy when it doesn't heal him, and it only extends the suffering. It's a right not to want. He doesn't want it. That is a right. Okay. What is not a right, when the person is on a ventilator or whatever, and they say it's no hope, it is disconnected ventilator. That is retziche, that is not right. Once on the machine, you have no right to cut off the machine.
Okay, let's give Jonathan Kovasnik, are you on? I see you're on. You want to put on your camera? He's a banker. I'm sure he has questions about that. Moshe Gutman, you're in the business field. Anybody else I'm missing?
Well, Elliot's question encompassed what I would ask, because I was looking at the very practical side. What do we do in a practical sense? And Elliot asked the question very nicely and got a very good answer. And thank you, Rabbi Schochet. And thank you, Elliot.
All right. Jonathan Kovasnik, I see you try, but you want to put on your mic and your camera? Start talking. Your camera's
okay.
Yeah.
So I have a question. I would like to know what is my obligation to give to organizations and non-family members compared to my family members halachically when I make out my documents?
There is no duty by itself, but there is an organization that is doing Shabbos. He gave my family every week for Shabbos. Now I got money. Obviously, I want to compensate them what it cost them. It's not a legal obligation, but that's a mitzvah. The mitzvah is always aniyeh icho koidmim. The people of your city, the poor or the organization or whatever, comes before the people, the poor people in another place. Eretz Yisrael is a special privilege. It's almost aniyeh icho. But otherwise, it comes always the people that you and mipsoch al tisalem. You have a poor relative and you have a poor friend. The poor relative comes first. Mipsoch al tisalem. You shall not. You have the first obligation when it comes to influence a person for Yiddishkeit or whatever. Is mipsoch, your relative is your first obligation. On the other one also obligation, but that comes first. Yes, what comes first?
I think his
So-
question is twofold. Is there an Jonathan, tell me if that's what you want to know. Is there an obligation to part of the will have a charity part? And according to what you just said, Rabbi Schochet, there is no flashiness. He wants to know if he should give a donation to something that'll have a building with his name somewhere to give it to support his family. Is there something? That's what he wants to know. I know him.
You see, the point is like this. There is certain thing interest. Interest is you get in your lifetime, you get interest from the bank. After that, the Shoma had no more activity. But the activity that he initiated in his lifetime, that he can take also for later on. When initiate, they say they learn on behalf of his neshama, or to give charity on his neshama, then the neshama has the benefit in Olam Emes. So therefore, he wants to do something not for the charity, for himself. It's big mitzvah for the stoker. Therefore, they say it says in the Parsha, Zor v'kesef v'nechoshes. Says you give the nation gold, silver, and copper. So some explain what is gold. Whatever you give when you're young is gold. Because then if you eat Sahara and you could it have you control it, it's gold. When you are old, is silver. When you're old, you're not anymore the Yitzhak. You don't sacrifice now an ice cream or a steak. The doctor told me not to eat steak. What is a sacrifice? But to save. So that is still something, silver. But you get after that, can I have any other from that money anyhow? It's copper. That's copper. Still works, still charity, but it's not the same that when you could use it and give it, than when you cannot use it and give it. That's copper. But definitely it is something. It is something.
Jonathan, sorry, I cut you off. You wanted to ask something.
Well, I was curious about the whole halacha thing about if I have siblings or my own parents' children and they cut us off and give all the money to charity in the last years of their life, and then that conflicts with what their secular document said, which was we were supposed to inherit their money. What does halacha say about the conflict that they secularly in a document gave everything away to charity, but really probably shouldn't have done that halachically?
You see, as long as he's alive, he has the full power. He has the full power. He doesn't have to give the children. The children are Yerushim. But as long as he's alive, it's not a Yerush, not inheritance. It's present. Present, he can give it or he can not give. He can promise and can change his mind. So when he acted after what he wrote there, that means he changed his mind. He's entitled to change his mind. It's not binding on the person that writes the will. A person can change a will. It's not binding him. It's binding the later on, but not him.
Okay, is there anybody else who, I know that we had some more, Isidore, you want to ask anything? Moshe Cohen, you want to ask? Anybody else? Rabbi Schochet, Moshe Cohen, you want to ask something? I know that you said you're going to give me 5 minutes. That was a long 5 minutes. That was very good. Schochet, thank you very, very much. This limit of Torah, Rabbi Schochet told me, I didn't even remember, even though it's my bubby too. It's his Rabbi Shochet's mother's yard site today. So let this learning and limit of Torah be Le'ilam Nishmasa, and she should have nachas from the family, and everybody should be gesund and stark. And we shouldn't have to deal with these issues, okay? It's a school of Arichas Yomim, right?
Yeah.
All right. Call to thank you again, Rabbi Schochet. Thank you, Jonathan. You want to say something?
No.
All right.
Thank you.
Thank you.
Thank you all.
I wish Schochet call to.